All right, thank you everyone. Thank you everyone who stayed with us all through these last 2 days. I hope that this has been a really positive and empowering summit for everyone so far. And I'm glad that we get to top it off with what's going to hopefully be a very, very brilliant workshop with legal aid providers and service providers in the employment field. So we understand how important employment is. We've discussed that a little bit already. We're going to be talking about the actual legal rights that people have during the employment application and hiring process. We're going to be talking about really understanding what a criminal record is and what record clearing remedies are and how they can help someone in finding employment. And we're going to be talking about occupational licenses for people who want to make a career out of one of the fields that requires licensing. So I would like to introduce Eva Dallaire from Legal Services for Prisoners with Children. She's a staff attorney there and worked there starting as a law student intern and then as a legal fellow, and seems to have stayed on for quite a while now.
They can't shake me.
They can't shake her. And then we have Brandon Green from East Bay Community Law Center. He's a graduate from Boston University Law School. He was a Martin Luther King Social Justice Fellow and Public Interest Scholar, and has been working on education and civil rights for a very long time now. He was also a legal fellow with Public Advocates of San Francisco, and he was a public defender in Contra Costa County, so he's seen many different aspects of the criminal justice system. And we have Sarah Crowley, who is the director of EBCLC's East Bay Community Law Center's Clean Slate practice, which helps people change their records, and we like to say change your record, change your life. That was the original Proposition 47 advertisement, but it's true for expungements, it's true for dismissals and sealing juvenile records as well. Being able to take control of what your criminal record says can be life-changing and can really steer you on or open up doors in terms of employment and housing and family reunification that might not otherwise exist. And then I would also like to greet Vinuta Naik, who is a staff attorney and is the clinical supervisor for East Bay Community Law Center's Clean Slate practice. She joined as a fellow in 2015 and has stayed on with them. And we're going to begin by talking about the rights in the employment practice. But before we begin, I would like to just take this moment to allow our guest panelists to say a little bit about what brought them to the work.
I think what brought me to the work initially was volunteering in a women's prison while in college and realizing the investment that the community and the state was really investing in me, which was about a little more than $50,000 a year. And at the same time, I was going into a women's prison 20 miles away, and the state was spending about $50,000 a year to incarcerate women and really devastate their lives, their families, their communities, and their futures. And so kind of acknowledging and seeing my privilege face to face is what moved me into this work.
Thank you. Hey everyone, I'm Vina. I'm a staff attorney at the East Bay Community Law Center. Can you hear me now? Okay. So I worked as a public defender in Marin County, and you get to work really closely with your clients for litigation, but as soon as the litigation completes or you decide to go with a plea bargain, you lose sight of that client, they go on probation, and that's when they have to navigate a very complicated employment process, a reentry process without having any advocate on their side. So that's what drew me to this work in the Clean Slate program, where we're helping folks who are formerly incarcerated get back into the workforce and be successful.
Hi, I'm Sarah Crowley, and I direct the Clean Slate practice where I work with Brandon and Vinitha, and then also we have a couple of colleagues who are in the back tabling, Martha Winokur, a volunteer attorney who just stood up, and Jael Myrick, who's our program coordinator, and then Jimmy Murillo, who's our Lutheran volunteer, also in the back. So please go and talk to them if you have more questions about our work. Like Eva, I think I was actually initially inspired by a prisoner's rights clinic in law school, and I've worked on as a civil litigator to try to reform criminal justice systems in various ways. And so I, in Clean Slate, lead the impact litigation work that we do when we see broken systems that again and again impose barriers to employment for our clients.
I'm Brandon Green. I'm an attorney in the Clean Slate practice. What brought me to the work is I'm from a community that's over-policed. I've probably been in handcuffs more times than I can count. More people I know have criminal records than college degrees. So the work to me is deeply personal. I became a lawyer to get access to power, and now I spend my days trying to disrupt systems. So my work at EBCLC is really on the criminalization of poverty. That could be anything from traffic court fines and fees to criminal court fines and fees, et cetera. So all these things where communities are over-policed, and that results in them having higher debt, higher incidence of driver license suspensions, et cetera, which end up translating into sometimes lower employment prospects. That's the kind of work that I do.
Thank you very much. I'm glad that everyone was able to make it today. And just so everyone knows, EBCLC now has a table set up in the back if you would be interested in accessing more of their resources. So we're going to begin just by talking, like I said, about the rights during the employment process. One of the #1 questions we get on our Root and Rebound reentry hotline is, how is my criminal record going to affect me getting a job? Or is it true that I can't get a job because I have a record? And the long and short answer of it is, no, it's not true that you can never have a job again just because you have a record. However, depending on what it is and how long ago it was and what jobs you're applying to, it may affect your ability to access that employment. So here's what you need to know going forward. Can we get the slides loaded up? So there are things that are not going to show up on someone's background check, but I think it's important for us to first define what people are talking about when they talk about background checks. So one of the things that gets confused all the time is people think that having their thumbprint taken and having their fingerprints done is the same as a background check by a private company. And this is actually not the case. Public employers, so government employers, generally go through live scan practices and are able to see much more of somebody's criminal record and background. Usually they have more access to the record of arrest and prosecution, so the rap sheet. And private employers, so companies like Uber over here and some of the other private employers in the field, are able to see things by going through a third-party background check. That means that they pay a company like Checker a certain fee, and then that company does the background check and provides the results for them. And because this is a consumer product and because it accesses sensitive information, it's covered by both federal and state laws. So the long and short of it is, there are some things that are going to be on your criminal record that won't show up during a private background check. Most companies that we know use private background checks. They don't do the in-person or the in-house background checks. An in-house background check would be if the employer is doing all the work on their own. At this point, most employers go through these third-party companies and have them generate the information for you. So, since there are things that aren't going to show up on a background check, what are they? And one of the things that should not be showing up on a private background check is usually negative information, including convictions over 7 years old. So we call this the 7-year drop-off rule. There's a lot of misinformation about this rule out there. There are people who have been told and believe that they've learned that after 7 years your record clears, and that's not true. However, what this means is that in a private employer context, when you're applying for a job and they run a third-party background check, a conviction over 7 years old shouldn't show up with a few exceptions for things like working with children or working with large volumes of cash. Arrests also aren't supposed to show up on somebody's background check unless they led to conviction or are still pending. So this is an area where there are lots of background checks that background check companies that don't do a very thorough job and don't look for the final decision made on those arrests. So these will show up, and employers often don't have the legal background to understand what the difference between an arrest and a conviction is, especially when reading it on a report. So this is one of the reasons why we recommend that everybody get a copy of their background check when they're applying for jobs. There are ways to get it before, depending on the company, there are ways to ask for a background check before you apply for a job, but there's definitely a way to ask for it during the job application process. So let me quickly just discuss what the procedural rights are during the background check process. So the number one right to be aware of when somebody is applying for a job is the notification and consent requirement. If somebody's going to pay a third party to run a background check on you, then they have to give you notice, which is just a letter saying we want to run the background check. It's going to be with this company, and they have to get your consent. So this is one of the boxes that people talk about when they talk about ban the box. There's a box that says, I consent to having this background check run on you. If you don't consent to having the background check run on you, they are not obligated to consider your application. So that they won't give you the job if you don't allow the background check. But at least you get the notification and are aware that this is going to happen. It's different than it's not permissible for a company to run a background check on you midway through you working for them without letting you know. So next to that, I consent to having this background check run on me. There should also be a box saying I request a copy of the background check. And then the employer has a certain amount of time to give that to you if they take any action against you. And we always advise people get copies of their background checks. So this is the box you want to check, because background check companies, some of them are very reputable. We have a very reputable one in the room with us today. But some of them are not as reputable, and others, even the best ones, might not have the proper information because court systems are slow to update. So we advise people to get a copy of their background check so they can see if there's any errors, any mistaken information, any outdated information. The number one problems that we tend to see on background checks are that charges that have been dropped or convictions that have been reduced or dismissed are still listed as what they were originally charged, which is often something much more serious than what the eventual conviction was, or that there's outdated information, or that there's someone else's information. So this is really common when somebody has a very common name. People have similar names, they use aliases, they change their name when they get married, and then things will show up on the background check from some other John Smith, maybe in an entirely different state, and it'll show up on your background check. So that's why we always recommend people to get copies of their background checks. One of the other rights that you have during the application process is there is a chance to correct any errors on the background check. The employer is obligated, they have to give you a chance to correct any of the errors on the background check. And they have to give you notice before they take any negative action. So if they're going to take a negative action, like not hiring you because of your record, or especially firing or suspending you because of your record, they have to give you notice and a chance to fix those problems. These are a few of the other things that don't show or shouldn't show up on a private background check. It includes things like diversion programs. So if you're sentenced to a rehab program instead of to jail or prison, that shouldn't be showing up. There are certain convictions that drop off if they're marijuana related. And most employers can't request a copy of your credit report unless they have an additional reason to think that that is relevant information. So that tends to be you're going to be in a supervisor role or handling large amounts of cash. And the other big thing to know is that an employer who's running a third-party background check can't see your full rap sheet. So most private employers will not be able to see the full rap sheet. And that's because a rap sheet is a private document between you and the government. It's a record of every time you've ever touched the criminal justice system, and it's none of a private employer's business to see that information. So they are not allowed to ask for it, and they are not allowed to see it. There are, however, some things that both public and private employers can ask about that won't necessarily show up on a background check. This is one of those kind of squishy areas of California law. So right now in California, like we said, under state and federal law, a conviction that's over 7 years old from the date of conviction can't be reported on a private background check. However, an employer can ask you questions about that. So on an application or in an interview, an employer can ask, have you ever been convicted of a felony, or have you ever been convicted of a crime? That's kosher. That's something that they can request of you. What they can't ask is they can't ask, have you ever been arrested? And a lot of employers don't know that they're not allowed to ask that. But the legal reason behind that is because an arrest doesn't actually prove anything. An arrest just, there is a very well-documented phenomenon called driving while black, which people are pulled over and over-policed because of racial profiling issues. And it has nothing to do with whether they've done anything wrong or have anything that would lead to the conviction of a crime. So for that reason, employers are not allowed to ask about arrests alone or a broader question that would capture arrests. So questions like, have you ever been in trouble with the law? Also not okay. And this is going to be something that EBCLC and Legal Services for Prisoners with Children can expand on a little bit. But as a general rule, employers can't ask about convictions that have been expunged or dismissed. So do you want to speak on that a little? Or?
Actually, I'll let Sarah hear it for it. We were just talking about it.
Sure. So under the labor code, most employers are prohibited from asking about or considering or obtaining from any source a record of a conviction that's been dismissed. There are some exceptions to that, most of which apply to public employers or employers that are specifically required to consider certain serious or violent offenses. So school employers are one example in some cases. But for the most part, an ordinary private employer is not allowed to ask about a conviction that's been dismissed. And many categories of public employers also are not allowed to ask about or consider dismissed convictions under the labor code. It's important to know, though, and I know we'll be talking, and maybe Eva and Emily will be talking a little more about Department of Justice background checks, where you get fingerprinted, and the Department of Justice sends a limited version of your record to an employer. Those will report dismissed convictions, even though in a lot of cases an employer isn't allowed to consider those. So that's just something to be aware of. And it's a good reason to talk to a lawyer anytime you're getting fingerprinted for a job, just so that you know up front what's going to show up on a record. I'll also just add one thing to something Emily said. It is true that in general employers can ask about convictions, but in a job application, under the law, they are required, if they're asking about convictions, they need to make clear that they are excluding from any question about convictions, dismissed convictions, or minor marijuana offenses. So anytime you see an application that just asks, have you ever been convicted of a crime, you should be wary and consult someone with experience about criminal background checks, because chances are most employers are not allowed to ask about any conviction with no qualifications.
Thank you very much, Sarah. So this is just a slide that highlights the difference between what can show up on a private background check and what can be asked. But what the big takeaway point from this is that there are rights that show up on a background check. You should know what the rights are regarding who you're applying to and what your record looks like, because it'll make a difference in terms of what an employer is allowed to see. And because these are very complicated issues that include labor codes, state law, federal law, different categories of employers, we highly encourage people to get in contact with organizations like LSPC and EBCLC and organizations like ourselves at Root and Rebound because of the information that we can provide from a legal perspective. This is an area, employment makes up so much of our lives, and it shouldn't be all tangled in legal red tape and minutia, but it kind of is. So that's why we're putting these services out there and bringing people here to network regarding legal aid and legal service providers so that you can reach out if you think anything is sending up a red flag for you, you think that you've been asked a question illegally, you think that you've been discriminated against on the basis of your record. There are people that you can reach out to and who might be able to provide guidance or even or some kind of legal support. So just to quickly talk about ban the box. So ban the box does not mean that employer can't look at your criminal record or can't ask about it. What it does do is delay how far into the process they can ask about your record. So for California, all government employers can't ask about your record until they've decided that you meet the minimum qualifications for the job. And in some cities and some counties, there's an even stronger protection in that it applies to private employers in San Francisco, or in a few other places it will apply to private employers who contract with the government. So this is another case where it depends on where you live. If you want information on it, you can reach out to the Human Rights Commission of any of the cities that you live in. The last one I want to highlight is for Los Angeles. Hopefully there's going to be more cities that pass ordinances like Los Angeles has in the future. Los Angeles makes it, first of all, it makes ban the box, which, like we said, delays when they can ask you about your criminal record. They make it apply to all private employers as well. They also put it off until there's been a conditional offer of employment. So practically what this does is that an employer has already invested all of this time in interviewing you, in checking your references, in deciding whether or not you meet the job, and then they can run the check. And the idea is that this gets people to treat you, or this gets the employer to treat people like human beings and look at them on a case-by-case basis instead of just tossing out every application that has a felony conviction on it.
And I'd like to just quickly add that Alameda County, as the county employer, as of January 1st, has stopped doing background checks at all for people applying to jobs there. And my understanding is that Alameda County, for private employers, had banned the box. Is that correct? I'm just making that up. Sorry about that.
In the future, we hope.
Yeah.
We dream of it. So just one of the last areas that I want to hit before I hand it over to Eva and EBCLC is that there can be discrimination based on record. And there are some ways to recognize when it's legal discrimination or illegal discrimination. According to federal guidance, it is probably illegal for someone to discriminate in a blanket ban way. Now, what that means is that if you see something that says no felons allowed or must pass sparkling clean background check, then that's probably a complete ban, or that's probably illegal in the eyes of the federal and state laws. And the reason for this is that when employers decide that they aren't going to hire anyone with any record at all, then they are disproportionately affecting communities of color. So what the theory is that this has what's called a disparate impact in legalese, which just means hits some people more than others, and that this is actually a subtext for racism. So we generally, if you see something that says no felons need apply, must pass perfect background check, that is a red flag, and you should get in contact with an attorney. You can get in contact with Root and Rebound about it, or you can get in contact with the Human Rights Commission of the city that you're in. There's also another type of discrimination that's a lot harder to prove, but does happen, and that's discrimination based on having a record plus at least one other factor. And what this can look like in practice is that an employer is only running background checks on applicants who are black, or applicants who have disabilities, or applicants who don't conform to gender stereotypes. If there is another factor that is protected under state or federal law, like religion, race, ethnicity, gender, or disability, and people are being treated differently based on identical records because of those factors, then that can be an unfair impact and discrimination based on record. And that is something that you would want to get in contact with an attorney about. One of the difficult things about this kind of discrimination is it can be really hard to prove that that was the factor, but that's why we advise people to get in contact with the Equal Employment Opportunity Commission and the Department of Fair Employment and Housing regarding any time something smells funky about these sorts of issues. They're supposed to have an investigation when those kinds of complaints come up. So I'm going to pass it over to Legal Services for Prisoners with Children now, and they can talk a little bit more about records. But those are some of the rights that we want people to be aware of during the job application process. So if anything starts feeling wrong, there are resources out there that you can reach out to and that can provide information on this. If you have a record or you're supporting a loved one with a record, you can get a free copy of our Roadmap to Reentry Guide, and we have all of the information that we went over here in the employment section of that guide, plus some, and we also include the Equal Employment Opportunity Commission and the Department of Fair Employment and Housing contact information. So we're going to get the slides pulled up for the next one, but I'm going to leave this over to Eva for now.
I'm Eva Dallaire. I'm a staff attorney at Legal Services for Prisoners with Children. I know we're called Legal Services, but we're actually a nonprofit advocacy organization working to change laws and the narrative around people with convictions. And we do that work through policy work, litigation, and community organizing. And our mission is to release people from prison, reunite families and communities, and to restore the rights and human dignity of formerly incarcerated and convicted people. And so our work really around conviction history remedies is about restoring your rights, and both on an individual level, taking the tools and the laws that are already here in order to restore your individual rights, but also getting together to improve the laws and fix these holes where we've kind of already started to identify to move the narrative, to move the law forward towards true equality. So what I want to cover today is just 3 real quick things: types of record remedies, the benefits and limitations of record remedies today, and the process for applying for record remedies. So the first thing is types of records. So one thing that you might want to do is reduce some of your felonies to misdemeanors, and there are kind of 3 ways that you can do that. There we go. Under Prop 47, which was a ballot initiative passed in 2014, it allows people to take some kind of felonies that always should have been misdemeanors and reduce them to misdemeanors, or maybe they shouldn't have been crimes. That's drug possession or theft under $950. Also, Proposition 64, which legalized marijuana, and I'm really excited to be talking about that today on 420. I realized that this morning. Takes marijuana possession and marijuana-related crimes and reduces them either to misdemeanors, infractions, or non-crimes at all. And unlike the marijuana legalization in many other states, California has made that retroactive. So if you have a marijuana-related conviction, it could be reduced or potentially dismissed under Prop 64. And then the last thing is Penal Code 17B, which takes some crimes that are wobblers, which means that the prosecutor could choose to charge it as a felony or a misdemeanor, and you can apply to have those reduced from felonies to misdemeanors. That list overlaps a little bit with Prop 47, and I'll talk a little bit about why you might choose one versus the other later. But better than just reducing felonies to misdemeanors, there are some felonies and misdemeanors that can be completely dismissed from your record. So it's now non-conviction data when you're applying for a job. But those are really limited. You need to have only served county jail time or probation. If you went to state prison, then you're not eligible for a dismissal. It only applies to California convictions, and most 290 convictions are also excluded. So there are other types
Sorry, I just wanted to quickly clarify what 290 meant. So 290 convictions are convictions that would put you on the sex offense registry.
So if you have a conviction that doesn't fall under that, or if you have some non-conviction stuff that's following you around, there are also some ways to reduce those impacts. I don't know why I put it in this order, but I'll start with the non-conviction data that you can reduce. Juvenile adjudications are not convictions, and so most employers cannot ask about them, but they'll still sometimes show up in different ways in your life. And so there's now a way to get rid of those juvenile adjudications. What I want to say about this slide is actually that you should figure out what your goals are for reducing your record and figure out what your convictions are that are holding you back, and meet with an attorney individually to figure out what strategies you need to take. Because those previous things are relatively easy to do, right? Yeah. But these other things tend to be a little more complicated. So if you have a conviction that you served state prison time for, you can apply for a certificate of rehabilitation. So it's still a conviction, it's still on your record, employers can still see it, but you can then say you're certifiably rehabilitated. So it's like, okay, that's great for what it's worth, but the process actually involves the district attorney sending an investigator to investigate you, interview friends, family, neighbors. It's really invasive, and it's ironic because the whole reason you have to get the certification is because you just came out of the Department of Corrections and Rehabilitation, and now you're trying to get certified, and the district attorney is saying, no, I don't think you're rehabilitated, even though you just came out of this prison that we're calling rehabilitation. But that is the first step to getting a pardon. It can really help you in other aspects of your life. So it may be worth it. You should discuss that. And there are other record remedies that I'm gonna let people kind of talk about individually. Within the conviction data that you can actually dismiss or reduce, there are mandatory and discretionary dismissals. So a mandatory dismissal means that the court is required to dismiss it if you petition for it and you meet those requirements. So that's going to be Prop 47, Prop 64, and if you had one of those dismissals that you completed jail or probation for perfectly, which means no convictions or arrests while you were on probation, and you've paid all your fines and fees, then the court pretty much is supposed to be required to grant your dismissal or reduction. But there are also discretionary things, in which case you have to prove to the court that it's in, quote, the interest of justice that you be allowed to reduce your record. So that's 17B, and I mentioned a bit ago that 17B and Prop 47 can overlap. And so as you're looking, you're like, well, if I have a conviction that's Prop 47 and 17B eligible, I'm for sure gonna do Prop 47, because that is mandatory. But one of the big things that 17B carries with it is the right to carry a gun, if you get the permit and all those other hoops. And so if you're trying to get your guard card or just really love carrying guns or hunting or something like that, you'd want to look for the 17B discretionary petition. And similarly, if you didn't perfectly complete your probation or your sentence, if probation was revoked or something like that, then it's considered imperfect, and you have to show that it's in the interest of justice to have that. There's a certain sick irony to that, of course, because people aren't just failing at probation because they're failing at probation. We're often failing because we're trying to get jobs. We're trying to get, to survive, and then to have to, or because you haven't paid all your fees. Now you have to show it's in the interest of justice that you be able to get your record cleared so that you can get a job. But if you could get a job with your record, you would have paid your fees. So anyhow, what I'm trying to say is there are processes. LSPC believes that they're not perfect, and they definitely have room for improvement. But use them, while they're what we have. And so there are certainly benefits and limitations to having your record dismissed. I'm gonna start with the limitations, because as you can hear, I'm a bit of a pessimist. So the limitations, so one thing is there's no such thing as a clean slate. If you think your rap sheet's currently 13 pages, and once you get your records cleared, it's gonna turn down to 1 page or something, it's still gonna be 13 pages. And those convictions, while they're now non-convictions for many purposes, they can still be used in for future court cases. So if you go to trial or take a plea bargain or something like that for a new conviction, they can be used as priors and enhancements, even though they're dismissed. Also, if you're testifying in a court case and your conviction had something to do with truth-telling, it can be used as impeachment as though it weren't dismissed. So the dismissal isn't making anything worse, it's just not improving this one aspect. It also comes up in occupational and professional licensing. And as we've talked about already a little bit, there's certain job responsibilities working with drugs, children, the elderly, law enforcement, things like that, where they're still gonna be able to consider non-conviction data. But there's still benefits, and we've talked a little bit about this already. In employment, well, let me take a step back and just repeat, because I practiced repeating this, so I'm going to. With convictions or non-convictions, there are only certain ways that, or with convictions, sorry, there are only certain ways that employers can consider those. And they can't have blanket bans, and the conviction needs to actually be related to the job duties. And so I noticed Emily said it's probably illegal, and I'm saying it is illegal, it just might not be enforceable. And that's another place where the law's kind of there, but kind of not, and we need to work to continue to improve it and to fix that. If they are gonna make not hire you or fire you or anything like that. They have to give you an opportunity to tell your side of the story. So that includes informing them that their information is wrong, informing them that they're misinterpreting the data, but also you have the opportunity to talk about rehabilitation or things that have changed. And then once they have that information, they're required to do kind of like reweigh all the evidence and think about how long it's been, how related it really is, and any evidence of rehabilitation that you have. But with non-conviction data, we've already covered this, so I'll do it very quickly. Private employers generally have a 7-year look-back period, and they can only look at convictions, and there's ban the box in many cities and counties. And if you're curious about which cities and counties, you can email me or you can actually Google it. NELP, which is the National Employment Law Project, has a nationwide survey listing every state and county and city that has ban the box implemented and what those specific rules are, because it changes. Public employers are not allowed to ask at the application, and because ban the box is statewide for public employers. And they can see but not consider non-conviction data, but the look-back period for them is basically forever. So when you're 80, they're still going to be able to see that conviction from when you were 18.
Eva, can I just jump in?
Yeah.
I'm just going to quibble with that statement that they can see but not consider non-conviction data in most cases. So
Please.
I think in the majority of cases, they're not allowed to see or consider non-conviction data. So the Department of Justice, really, there's a limited category of employers that are supposed to be receiving non-conviction data if they're getting it from the state. So it would be peace officer employers, and then employers at health facilities or facilities that serve vulnerable populations can get limited categories of arrests. And then anyone who's getting an FBI rap sheet, you should assume they're gonna see non-conviction data. But just generally the rule is even public employers won't see and can't consider non-conviction data.
Thank you.
Yeah, sure.
Look at that, it's better than I thought. And then there are a number of reasons not related to the 9 to 5 why you might want to clear up your record. That could be if you have, I know someone who was trying to adopt her granddaughter and she needed to get a certificate of rehabilitation to be able to do that. Housing, occupational and professional licensing, getting into college, immigration, and visiting loved ones in prisons, among, I'm sure, so many other reasons. So if you're not happy about these limits, as you can see, I'm not thrilled with them. I'd like to invite you to join us to fight to improve these laws. Legal Services for Prisoners with Children is having our annual Quest for Democracy Day, which is our annual advocacy day at the state capitol on May 7th and 8th. So there'll be a training on Sunday the 7th, and then a rally, and we meet with every single state senator and assembly member to tell them our stories, our experiences, and why they need to improve the law and really push to change the narrative that's happening in the state legislature. Now I'm gonna get really quickly into the process of applying for record remedies, unless y'all are covering it. Okay, so the first step is to get a copy of your rap sheet. RAP, you'll notice, is all capitalized. It's because it's an acronym. It stands for Record of Arrest and Prosecution. Fun fact. So I lived in Pennsylvania for a number of years, and in Pennsylvania you could get on the court's website and search anyone's name. My husband's name is James Brown, so I would regularly search his name in Philadelphia, and like 8 or 10 people would show up, which was terrible for your job prospects, but great for doing record clearance, because as an attorney sitting there with the client, I could just be like, oh, here it is. All right, let's clear these. These are clearable. In California, you have a lot more privacy. No one else gets a copy of your rap sheet. If an employer wants to run a background check, he or she has to get permission from you to do that. But it takes time, and it costs up to $50 to get a copy of your record. If you go to a clinic like EBCLC's, you can get that waived, right?
The fee?
Yeah.
Yeah, depending upon income, you can get it waived. I also just wanted to say, currently, at least right now, Alameda County on their website does have a way for folks to type in people's name and see lists of convictions. We have been trying to push back against that. There's supposed to be a firewall, a payment wall being put up, but exists in other places other than Alameda County as well, and it has a lot of errors. So and we can get into this later, but because there's different kinds of rap sheets, and they pull from different information, and private employers pull their information from various sources, there's all kinds of room for errors, and there's not as much privacy as folks would like or anticipate currently.
Yeah, to add on to what Brandon said there have been some studies on FBI rap sheets that show that about 40% of them have errors on them. And if you've ever been to a record cleaning clinic or looked at a rap sheet, you know that they are very complicated and can be very difficult to understand what the information on the rap sheet is trying to tell you. So it's one of the reasons that we definitely advise people to get a copy of their rap sheet if they can, so that they can see if there's anything on there that is inaccurate, or one of the major things that we see is stuff that's very unclear, or convictions that are listed multiple times. This is a funny story that I've told before, but we once saw a rap sheet that had 7 attempted murder convictions, because it was the same attempted murder conviction that was repeated multiple times, but it just looked like that person was like really bad at murder. Like it created a false, there we go, that took a minute. It created this false impression that this person had been in trouble with the law many more times than they actually had been.
So once you get that questionably accurate rap sheet, you would meet with an attorney. There are a number of organizations across the state. If anybody hears from, oh, he's gone, the South Bay, anyone? No? Okay. But if you're here in Alameda County, you would go to EBCLC, conveniently at this table and at that table. To meet with someone, figure out what your goals are, what remedies are available, and then how to create a path to move that forward. And then applying for the remedies. The forms are really simple, but what's more complicated is writing the declaration and getting kind of letters of recommendation and certificates to show the court that it's in the interest of justice that they give you your expunge or your dismissal, if it's a discretionary dismissal.
Eva, can I just add one thing to that point?
Please.
So earlier you spoke about prison convictions. So at EBCLC, we take the position that if you're eligible for Prop 47 or Prop 64, once you get that conviction where you serve prison time reduced, you are then eligible to apply for this dismissal under 1203.4A, which is a misdemeanor with a non-probationary sentence. And so not only should you just get the reduction, but you should get the benefit of the actual dismissal expungement statute, which then protects you for private employers. So the reduction alone doesn't help you for employment. It's the reduction plus the dismissal. So you should definitely look into that. So if anybody has ever been to prison, or know of anybody who's been to prison for a marijuana offense, for a simple drug possession, or for any type of theft, forgery, receipt of stolen property, you should definitely speak to an attorney and see if you're eligible for that reduction plus the dismissal. And we have our flyers back there as well if you have convictions in Alameda County.
Thank you. So then the last step, once you've gotten your record dismissed, is to get a new copy of your rap sheet to make sure that those records are accurately updated and dismissed. Because as we were just discussing, it's a huge problem, these inaccurate remedies, and inaccurate records, and what's the point of going to all the trouble of dismissing your cases if it's still gonna be marked as a conviction. So that's all I have.
Thank you very much, Eva. Now, East Bay Community Law Center is going to speak about occupational licenses, and that's going to kind of tie some of the things that we've already discussed all together.
So, just to quickly get started, so this used to be the assumption of how reentry worked, right? You would go through the clean slate remedy, you would get your record cleared, you'd apply for a job, and then you'd get a job. But we know that that's not really the way that it works. You usually need to do way more than that. We can get into later sort of how you forecast what these things may look like, but you can see from this slide that there's various things that need to happen. So, related to what Eva said, there's a public education aspect to all of this, because though there is currently in most parts of the country some sort of national consensus about the way in which the criminal justice system deprives people of opportunities, the law is not caught up in most places. So there's still a lot of policy work to be done. So the folks, and that policy work should be done in conjunction with folks who are actually impacted. And then, you need to do employment advocacy, which is part of what we do at EBCLC. In addition to representing individual clients, we sometimes sue background check companies. We sometimes help clients advocate for themselves with background check companies, et cetera. Then we help folks clear their records, and depending upon where folks come through in our pipeline, we also represent people in administrative hearings for occupational licensing. And so we can get into that a little bit later as we go through this.
And so we're gonna focus this piece on occupational licensing to complement what Eva and Emily talked about, and also because this is a big deal for workers in California. 30% of California jobs require some sort of occupational licensing and clearance, and so when you're thinking about how to get a job with a criminal record and how to find family-sustaining employment, being aware of barriers that you're likely to face based on a criminal record in the occupational licensing sphere is a really important piece of that. In particular, some of the fastest growing job sectors and the jobs that are really gateways to solid career enhancing type employment carry kind of a heavy licensing requirement. So healthcare is one example. If you can sort of get in the door, then there's a lot of opportunity there. But being savvy about licensing screening is an important piece of that. I also want to echo what Brandon and Eva have said about public education and about moving the policy dialogue forward. I've realized that we're about to go into a series of slides that are a little bit gloom and doom, because they're kind of about all the different exclusions that happen based on criminal records in the licensing sphere, we don't want to sugarcoat it. It's a very difficult process to navigate if you have a criminal record. And so part of what we want to do is really just alert people to the fact that you shouldn't be deterred from going into fields that require licensing or certification just because you have a criminal record, but you should approach it in a really savvy way. You should consult with lawyers as early in the process as possible. You should explore all the criminal record remedies you can, and just be aware of what's going to get reported and how to present your criminal record in the best way possible. So gloom and doom slide number 1. Sorry. So there are certain types of exclusions that that people with criminal records face in the licensing context. You've heard a little bit about blanket bans. There's a number. This is a slightly different use of the term blanket ban, but most licensing agencies have certain categories of convictions that will just bar you per se from licensure. And so that's one reason why, in the slide that Brandon showed with the blue bubbles and the green bubble, we encourage people to sort of consult with lawyers and kind of know what they're getting into at the time when you're starting an education program, at the time when you're starting to think about going into a nursing program or becoming a chiropractor, any of those things, because you want to know at the outset what you're going to have to do and if there are barriers that you just ultimately wouldn't be able to overcome. There's also, in most cases, discretionary exclusions. So there's certain categories of offenses for which an agency is allowed to exclude you, but is required to use discretion and consider the individual circumstances. And then one thing we keep an eye out for and want to hear from all of you about is cases where licensing agencies are excluding people unlawfully, based on information or records that shouldn't be the basis for an exclusion. And that's when we bring lawsuits and use other advocacy tools. Another a set of problems, gloom and doom slide number 2. Another set of problems we see are just sort of problems with licensing agency processes that harm our clients, and they're things to be alert to when you're going through a licensure process or thinking about doing it. So you want to be sure to request a copy of the background that the licensing agency is relying on in denying you a license or a certification. And we're gonna talk in a few minutes about the DOJ live scan process. You are entitled to request a copy of that record if it's used as a basis to deny you an employment or a job or license. There's also inaccuracies, so be alert for inaccuracies. There are often delays in the process. And in some cases there are specific rights to have a decision made within a certain period of time, and in some cases it's just a case where you have to be a squeaky wheel, and lawyers can sometimes help with that.